Good morning, everyone. And Sunday mornings and webinars usually don't go together, but the occasion is such. It is, yeah. I'm not just talking about Chaturthi in this part of the world for Lord Ganesha and Kadwa Chauth in north and a big part of India, but also a very auspicious day to launch a new book, a book that's been in the works from the side of we, the publishers, Thomson, Reuters, and Taxsutra, for almost 6 months. That's the sort of detailing that's gone into this book. Patent laws, cases, and synthesis by one of the renowned experts on this subject, Advocate Adarsh Ramanujan. I'll of course introduce Adarsh in a while, but we are really grateful to the eminent dignitaries that are there to grace this function virtually. How I wish we could have done this function right in the heart of Delhi at a physical book launch event. It would have been a lot more fun, but that is not to be. Hopefully, we'll be averting the third wave. Hopefully, in January, we could still have a shot at a third book launch, at a physical book launch function. But it's a pleasure, an absolute pleasure to be welcoming the dignitaries for the day. We have Honorable Justice Pratibha Singh from Delhi High Court, sitting judge of the Delhi High Court. Madam, it's an absolute honor to be hosting you at this book launch function. We'll be hearing from Justice Singh in just a short while. Senior Advocate Dr. Abhishek Manu Singhvi, one of the doyens of the bar. We have two doyens of the bar today, Senior Advocate Dr. Abhishek Manu Singhvi and Senior Advocate C.S. Vaidyanathan. I have had the pleasure of hearing them argue live in the courtroom, and I still remember Dr. Singhvi's arguments in the Tata Mystery matter at the NCLT, the absolute extempo. It was as you would call it, masterclass in arguments at the court, and I still remember some of the quotes from Shakespeare that Dr. Singhvi had mentioned during the hearing. It got a bit heated, but I loved every moment covering it and writing word by word what he'd argued at the court. It's been a pleasure to have covered them in the courtroom for the last 17 years as a journalist. We'll formally unveil the book. I request Tanaya, my colleague, to bring up the screen so that we can all see the book. Yeah, Tanaya, could we see the screen? Yeah. Patent law cases and materials. This is the ebook is hosted on Taxsutra's ebook platform, where we have over 500 books now from different publishers. Patent law cases and materials, a synthesis for India, and this is the one. Yeah, and we can, Tanak, we can come out of the screen. That's fine. And yeah, now before I ask Adarsh a few questions, I'll request Gauri, who's been a partner, who represents Thomson Reuters and Nugent, to please offer a formal welcome to all the dignitaries and the authors.
Thank you, Arun. Yeah. So, Honorable Justice Pratibha Singh, Honorable Judge of the Delhi High Court, Dr. Abhishek Manu Singhvi, Senior Advocate and Member of Parliament, Senior Advocate Mr. C.S. Vaidyanathan, Mr. Arun Anandgiri, Editors Taxsutra, our esteemed author, Advocate Mr. Adarsh Ramanujan, all the dignitaries, members of the legal fraternity, a very good morning. On behalf of Thomson Reuters and its contracting affiliate, Nugent Knowledge Works, it is my privilege to welcome this august gathering today for the release of the book, Patent Law Cases and Materials, a Synthesis for India. The effort through this book has been to fulfill a long-felt need on the fundamental principles of patent law from an Indian perspective. The casebook format of the book suits practitioners and judges and allows readers to independently interpret and assess the implication of each case law. From an academic perspective as well, it provides relevant Indian provisions and extracts from relevant case laws across India, the UK, EU, and the US. This approach is ideal for India, where jurisprudence on the subject is limited. It is befitting that Honorable Justice Pratibha Singh has consented to release the book and deliver the presidential address. And I wholeheartedly welcome Honorable Justice Pratibha Singh, Judge Delhi High Court, for this August gathering. Dr. Abhishek Manu Singhvi, Senior Advocate and Member of Parliament, has graciously accepted our invite to be present on this occasion, and I welcome him on behalf of Thomson Reuters on this occasion. Sri C.S. Vaidyanathan, Senior Advocate, has been closely associated with the author, and I welcome him on behalf of Thomson Reuters on this occasion. Arun and I have been closely associated on various book projects. And when we first spoke about this book, the author, topic, we at Thomson Reuters were more than happy to publish the same. And it was, I think, probably a 5-minute conversation that we accepted. It's been a pleasure to work with Arun, and my thanks to him for inviting me for this book launch. Advocate Adarsh Ramanujan and I were first introduced regarding this book, I think, like Arun said, about 6 months back. And my team has been working closely with him in ensuring that his needs from a publishing perspective are taken care of. We have seen his attention to detail when developing the content for this book and subsequently at various stages of production. It's not every author. There are times when we get manuscripts and we complete and give it back. But this time, he's been closely associated in the production of this book. And we wish him the very best for the book and are confident that the book, Patent Law Cases and Materials, a synthesis for India, would be very successful. Our special thanks to him for his support during this production journey of 6 months. With these words, I once again welcome everyone to this book release function. Thank you.
Thanks, Gauri. It's been a pleasure partnering with you on the book. The book quality of the paper, the way the book has come about, the hardback. I think it's going to be a pleasure reading it. And I must make a special mention of the editorial team at Nugent, who worked round the clock to bring the book out on this date. It's a bit delayed, but that's because the Nugent team loves to dot the I's and cross the T's at times, to the chagrin of the authors and the co-publishers. Others, sorry for that. But this is your day, Adarsh, and we would love to hear from you. Before I ask Adarsh a couple of questions about the book, and he speaks about it, his passion, his labor of love. And this is one of the most insightful commentaries, which is now in its second edition. I'll introduce Adarsh and then put a few questions to him. Adarsh Ramanujan is an independent counsel practicing primarily on the litigation side. He has represented clientele in a wide range of sectors. Adarsh has been involved in handled disputes in diverse areas of laws, intellectual property litigation, commercial arbitrations, IBC, competition law, contractual disputes, international disputes, and so many other laws and legislations. He draws from his considerable exposure and experience in international laws and a 3-year stint in Geneva, Switzerland. In his current and previous roles, he's appeared before a variety of domestic and international forums, including the Supreme Court, various high court tribunals, the WTO, the EU Commission, US Department of Commerce, and US International Trade Commission. He is one of the youngest persons to have represented a sovereign government as an arguing counsel before the WTO. In his spare time, he's delivered lectures and courses on advanced patent law, commercial arbitration, and international trade law across Indian and European universities. He's published over 30 articles in reputed national and international journals on a variety of topics, including IP, international trade, tax, regulatory, and constitutional law. He also regularly writes op-eds with reputed news publishers and contributes to blogs. Adarsh, all yours. We want to hear from you your initial thoughts on the revised edition of this commentary on patent law.
Thank you, Arun, and my pleasure to be sharing the dais with such great dignitaries, doyens in law from the bar and the bench, and particularly in IP. I don't think anybody practicing in IP can say that they don't know these people. They need absolutely no introduction. It is really my pleasure, and I'm humbled that they've taken the time not just to go through my book, but also attend this event. Thank you for that. All I can say about this book is I have a passion for patent law since law school. And that is primarily because I come from a family of science, and I was the black sheep by ignoring science and taking law as a profession. But That love for science has always remained. So patent law has been a passion for me for a long time. And when I started reading patent law in law school, I realized that for every principle, I had to actually start looking for judgments. I mean, I couldn't find really good commentaries. And every time I pick up judgments from overseas, I then need to go back to the Indian statute, figure out to what extent I can apply it, are there exceptions, are there limitations. So for me, this book is actually a collection of thoughts that I have been jotting and collating for over 10 years on different aspects of patent law. The lockdown gave me the time to put this together in a cohesive format and then bring it about as a book. Typically, people question, first edition came out just last year, and then you already have a revised edition. But the interesting point is that even surprisingly, unlike it is unlike of patent law, but surprisingly, this 1 year has had very, very interesting developments across the globe when it comes to patent law. So it gave me a good opportunity to revise the book also. And the idea behind the book is whoever be the audience, lawyers, judges, practitioners, patent office, etc., they'll have something to take away from the book. The idea is to present that level of information. And now we've also had the opportunity to put the entire compendium in volume 2. So that volume 2 will give you the entire legislative history behind patent law and the current law. So it's a compendium that people can use to fully figure out the statute and the basic materials. So from that perspective, I will say that this has been a dream of a decade that is now coming to fruition. And I hope that people find something of value from the book.
Others, between the first edition and the second edition, we possibly had a gap of around 3 years, if I'm not...
About a year.
Year and a half,
Yeah.
fine.
Yeah.
But over the last 3 to 5 years, do you think, others, that there's been a lot more chatter about IP laws? A lot of people now attach a lot more importance to IP, maybe because of so many of these M&As that happen. People do IP due diligence or whatever. So much of the value is derived from the IP. You look at the new age companies, the unicorns, whatever even we do, maybe at Taxsutra or whatever, everything is content, everything is your IP, the proprietary the innovation. So do you think that there's a focused focus today on IP than maybe 5 years ago?
I would think so. And I would say it has been progressively the situation since about 2005. Since about the early 2000s, there has been an increased chatter. And I would agree with you that the past 5 years seems to be especially critical in the way people have talked about IP, because now I've realized the discussion of IP used to be for a long time, with a small group of quote unquote IP lawyers. But then I see that in the past 5 years, a lot more practitioners are doing different types of IP. So it is no longer such a closed group, is my sense from the practice. And from a more normal citizen, the Aam Aadmi point of view also, I believe that more common people are discussing and are talking about IP much more than they were 5 years ago. Perhaps it is the entire vaccine scare that has brought this into the picture. Perhaps there are other factors involved. There is more press coverage about IP and IP related issues. So overall, the chatter has definitely gone up. That would be my view.
Yeah, Adarsh, I'm once again bringing up the book screen. I hope that can be seen here. The book screen is right here. Patent law cases and materials synthesis for India. And this is volume 1. It's in 2 volumes. And yeah, it is heavy. Legal books, commentaries are always heavy, as we can see on all our speakers, background. Adarsh, I'll just ask you one more question. We all want to hear from dignitaries today, including you. So Adarsh, in terms of, we all talk about a global economy. The world is becoming one, small, intertwined. So when we say that, do you see the Indian jurisprudence also taking a page out of the global jurisprudence, or vice versa? And have you covered that in the book?
I think the answer to that is a little more complex. I think the speciality of India historically, and I'm not talking about just IP or law, I'm also talking as a student of history. The greatest speciality of India has been to Indianize everything. Right from cooking to ingredients to concepts to principles, we take and we make it our own. I think that is something so special about this country historically. And in my opinion, that is equally true of patent law as much it is true for many other positions of law. We are going to take, and we are continuously taking leaves from different jurisdictions. But I think at all times, we are keeping our head down, looking at what is going on in the country, and we're Indianizing it in the way that suits the country. That would be my answer to that question.
And how many cases are there in this book, Adarshan?
Beg your pardon?
How many cases are there in the book? How many cases did you count while writing?
I mean, in terms of the extracts that we've really put out, I would say easily about 40 to 50 extracts. And if I discuss the number of cases I would have read to condense the material, I don't know. My guess is yesterday I was checking, in fact, because my wife was asking me the same question. I think I had digested about 700, 800 cases before I come up with this commentary. So it did take a long time, but of course the 700, 800 is spread across so many years. Anyway, that's what I would want to contribute.
And I will now, Adarsh, thanks so much. And we'll keep coming back to you because, it's your show, the book launch. But it's a pleasure right now to introduce formally and Honorable Justice Pratibha M. Singh. And we're really grateful for her time on a Sunday morning for this book launch function. And we're really so eager to hear her wisdom on the subject, because she is not only, Madam is not only a sitting judge of the Delhi High Court, but a subject matter expert as well. Honorable Justice Pratibha M. Singh has completed a 5-year law course from University Law College, Bangalore. She graduated as the first rank holder from Bangalore University and also represented India at the Philip C. Jessup Moot Court competition in Chicago, USA. She was offered the Audace Scholarship by the Cambridge Commonwealth Trust to study LLM at the University of Cambridge, UK. She enrolled with the bar in 1991. Before being elevated to the bench, she was a leading intellectual property lawyer in India. She had the distinction of handling landmark matters in all areas of IPR laws, including patents, trademarks, designs, copyright, plant varieties, internet laws, etc. As managing partner of Singh & Singh, she advised clients and handled cases relating to commercial disputes, arbitration, telecom, broadcasting laws, media laws, writs, regulatory issues, education, literally the whole gamut. She has regularly appeared before the Honorable Supreme Court, High Court of Delhi, TDSAT, IPAB, that is the Intellectual Property Appellate Board, Trademark and Patent Offices. She was appointed as amicus curiae by the High Court of Delhi to streamline the working of the Copyright Office. She was also appointed on the high-level committee for streamlining of patent examination. She was invited as an expert to present views to the parliamentary committees considering amendments to the Patent Act in 2002, Copyright Amendment Act 2012, Geographical Indications Act, etc. Mrs. Singh was designated as a senior advocate by the Delhi High Court in December 2013. The Pratibha M. Singh Scholarship for LLM students was instituted at the University of Cambridge in 2013. Scholarships are granted to Indian students who have secured admission at Cambridge for pursuing their LLM course. Recently, she has been invited by the Vice Chancellor, Cambridge University, to be a part of the Circle of Advisors for India. She was a member of the IPR think tank, which was entrusted with the momentous task of drafting India's first national IPR policy, which was released in May 2015. She's also been awarded as 30 Most Powerful Businesswomen in India award by the Business Today Group in September 2018. She's written a lot of insightful articles on this subject. During her tenure as the president of APA Indian Group, several important initiatives were taken, including filing of a writ petition, seeking constitution of the IPAB, as also the creation of the Delhi courtroom complex for IPAB. She's been a prolific speaker all through, and also was a member of the CII National Steering Committee on IPR, and she's been a recipient of several awards, including IP Litigator of the Year 2012, the Asia Women in Business Law Awards given by Managing IP for Excellence in Litigation. So without any further ado, I request Honorable Justice Pratibha M. Singh to please share her wisdom, and we are delighted to have presented the hard copy of the book already.
A very good morning to all of you. Thank you, Mr. Arungeri, for the kind introduction. And Mr. Nitesan, thank you for the initial welcome remarks. It's my immense pleasure to share the screen, if I may say, with Dr. Singhvi and Mr. Vedyanathan. It is a strange feeling, because when such senior counsels of such repute, whom I myself had the pleasure to brief in several matters in IP, when once a person is elevated to the bench, you have to have that distance and that formal dispensation. But that doesn't take away the fact that long ago, when one was in practice, there was interaction on a daily basis with the two of you. And I've enjoyed immensely briefing the both of them. And of course, various other senior counsels during my practice until I myself became a senior counsel. And secondly, I want to say that, it's also a pleasure to share the screen with Adarsh Ramanujan, with whom I had the occasion to work very closely in several matters, including the Monsanto litigation. And it's just by chance that that was the last case I was arguing before the Delhi High Court, when I was told that the notification was issued for my elevation. And so that was the last case I appeared in the High Court itself. So Adarsh, heartiest congratulations on your book, the first edition, which I had the occasion to read in detail. I have received the second edition, but I have to confess, I haven't had the time to see the differences and map them. But I had analyzed the first edition thoroughly, and I had written that forward chapter-wise after reading all your comments. The first and the foremost thing that I would like to say is, in Indian patent law, there have been very few scholarly works. And when we go back in history in patent law, the two most important scholarly works which happened in India was the Bakshi Tekchand Committee report and the Justice Rajagopal Iyengar Committee report. Both these reports were known for their complete in-depth analysis, the critical analysis as to what India should look at and how the law should be. You'll all be shocked to know that, normally law is actually introduced, which I'm not sure if it promotes the industry. It normally regulates industry. Law normally regulates industry. But these two commentaries, these two committee reports, which led to the enactment of the 1970 law, we all need to thank these two big scholarly products which were produced in those committee reports, which led to the enactment of the 1970 patent law, which had an immense impact on India. And we have to thank them even today, especially during the pandemic, because the Indian pharmaceutical industry and the contribution that it has been able to make during this pandemic has been a result of the vision that these two reports, especially the Justice Iyengar Committee report, brought to India. And India has a lot to thank for the growth of its pharmaceutical industry. And these two scholarly works led to those amendments. And I do believe that after that, if there was another scholarly intervention, I think that was in the drafting of 3D by Justice Krishna Iyengar and his team, when India became member to the TRIPS agreement. And we debated this in Parliament. If you all look at the Novartis judgment in the Supreme Court and our own research, when we argued the Novartis case before the Supreme Court, the debates in Parliament were absolutely scholarly. One of those great exceptions when across party lines, all parliamentarians debated in in-depth manner as to what the law should be in India. And again, in the pandemic, people are thankful to India from across the world that we do have these forward-looking provisions, very practical provisions in our law. And I think that Adarsh's book is very, very timely in this context, because it is a scholarly work. It has a very unique structure. The structure of this book is, it only deals with 10 major aspects of patent law. And as they say, Adarsh has learned as to what is to be ignored. So he's ignored it quietly. And in each of the 10 topics, Adarsh has picked a structure of having 4 elements. International case, the concept itself, the international case law on the subject, the Indian case law on the subject, and his own comments. So whenever anyone needs to learn or read or understand any of the 10 topics that he has touched, all the important topics, including inventive novelty, inventive step, person of, ordinary skill in the art, infringement, revocation, compulsory licensing, coverage disclosure, all of these important issues, he has done a thorough analysis of the concept itself and how it falls into place in the Indian context. So I really commend practitioners, industry, lawyers, senior counsels, any academicians, anyone who want to learn anything about patent law, to definitely take a look at this book, because it is really commendable venture by Adarsh. And as I say in the foreword, I think this is just the beginning, Adarsh. You will have many, many more scholarly publications. Let's come back to, I don't know how much time I have, because I was told about 10 minutes. So I think I've already taken 5 minutes. I'll take 5 more minutes on speaking about generally in patent law, what is the way forward that we need to look at. There are 2 debates that always happen in India when we start looking at patent law. Do we need patents? There's always a question. And does patents spur innovation? So these are two issues which are always raised when we debate about patents. And one need not go too far. A reading of a few paragraphs of the Iyengar Committee report rests this debate beyond any doubt. Patent law is the only practical way and solution to spur innovation, to ensure that innovation is protected and recognized in every possible manner. I'm sure that this is not the perfect solution, but the world has come up with this solution since 1642. And therefore, I don't think we need to debate this anymore. It's been too long to debate this. Secondly, I think that patents, as the pandemic has shown us, literally has brought the world back on its feet. The kind of fast innovation that has been done during the pandemic, according to me, it needs to be owed to the ecosystem of patents internationally. So while there are issues about sharing of patents and TRIPS waiver, patent waiver issues, which can be debated, discussed on the practical ground, if not for patents, this ecosystem would not have existed. So we owe it to the patent ecosystem. The second thing I would look at in terms of IP being of importance is, since the last 5 to 6 years, we've noticed that after the initial years of bilateralism, which happened in the 70s, 80s, etc., the early 90s saw multilateralism in the form of the World Trade Organization. So all our patent law and amendments happened during this period from 1995 onwards. But with 2015 or 2016 onwards, I do see this clear shift from multilateralism to bilateralism. And in the bilateral context where countries are negotiating free trade agreements between each other, the importance of IP cannot be lost sight of. Every FTA, which you can imagine, whether it's the FTA with Europe or the US or UK, which is currently being negotiated, there are several areas which relate to intellectual property, and a large amount of the IP negotiation is focused on patents. And therefore, patents is going to be the biggest negotiating point. For example, issues relating to data exclusivity, issues relating to, patent linkage and extension of patent term, etc. These are going to be negotiated. And we should not be surprised if we start re-looking at patent law in the manner in which it was looked at, different from the manner in which it was looked at in the past. Now, coming back to Adarsh's book, there are a few comments I wish to make. The emphasis which Adarsh has given in the context of the Iyengar Committee report on working of patents is something that patentees need to look at very, very seriously. And I think the ecosystem for investment and manufacturing, if it's increased, working of patents should become a practical reality. He has very frankly stated that Section 8 needs a relook. And I mean, that may be something which legislators need to look at. He has not hesitated. He's been a bold author who has critiqued the judgments of the High Courts and the Supreme Court, including the Roche versus Cipla judgment and other judgments from the Supreme Court. He's also written on relevance of prosecution history in how infringement and validity is debated. I think that's a very good critique by him. The biggest challenge in India currently in the field of pharmaceutical patents is on coverage versus disclosure owing to Marcus patents. And he has taken that debate heads on and given his own view on this matter. Section 13.4 on whether the patents should be deemed to be valid or invalid while coming to court. I think he's got a very interesting perspective. And he says, let's not presume there is validity, but let's also not presume that they are invalid. So it's a very interesting way of putting it. And once patents go through so many levels of challenges, whether Section 13.4 needs a relook, he's pointed out various drafting errors in the legislation. And finally, talked about public interest as well, very nicely, how public interest has become the fourth element while dealing with patents. I think Adarsh's book will be a ready reckoner for all practitioners and even for judges. Now that I'm on the bench, I can say that I would definitely want to look at his book if I'm next time deciding any patent case. And thank you for the ready reckoner, Adarsh, and for the publishers. Just one more minute I would like to spend on what is the way forward. Because if I don't spend a minute on this, I think it'll be missing we'll be missing the main point. The IPAB has been abolished, as all of us know. There was a big concern as to what is the way forward for India in IP and in patents. And we've been lucky in the Delhi High Court. Committees were constituted. So there are two major rules that are being published. The patent rules of the Delhi High Court, which were put up for stakeholder comments last year, and the IPD rules of the Delhi High Court, which have been put up about 2 weeks ago. The Delhi High Court has decided to constitute the IP division, and these two rules should streamline the manner in which IP matters are going to be tried in our court in a big way. And we really hope that the bar and the industry responds and gives us their comments so that all their inputs could be considered. And the way forward I look at is India is on the cusp of a very big IP revolution, according to me, especially in litigation, because the abolition of the IPAB has brought the entire story back at the foot of the judiciary, that is to the courts. And we need to innovate newer ways of dealing with IP litigation. And I think IP divisions are the way to go. We have the Japanese model, the Korean model, and the UK model to look at. And I do think that if we have more judges in our courts, hopefully appointments will happen. There should be dedicated benches for IP cases, just like we have dedicated benches for income tax and for, company courts or arbitration. Like that, I think IP would be a major roster within the Delhi High Court. And when this happens, I do believe that we would be able to streamline IP litigation to a considerable extent. There are various new elements in the IP division rules, which of course everyone can see them, including the manner in which technical help needs to be taken by judges, because judges can't understand. You cannot expect judges to understand all technical aspects of patent law. So I do believe that the practitioners like Adarsh have a very big contribution. And I would just like to end by saying, as we go ahead and set up IP divisions, hopefully other high courts are looking at it. And I'm told that there are committees constituted in other high courts to look at how to deal with IPAB abolition. There should be more and more practitioners who should be considered for elevation from the IP field. I think that would really contribute to the IP jurisprudence of our country. India has a very rich jurisprudence in IP, especially in patent law. And all the best to Adarsh for his going forward. Please write more books, and I'm sure that's going to be helpful. And heartiest congratulations to the publishers and the author. Thank you very much.
Thanks so much.
Grateful and humbled, ma'am.
Yeah, thanks so much. And I'll just bring up. I'll try to bring up the yeah. Can I bring up the? I don't know why it's not. Yeah, here is the forward that we just heard some snippets from Madam. This is Honorable Justice Pratibha M. Singh's forward. I think it is visible, and yeah, this is a line that I would read from it as the last paragraph. As the well-known philosopher William James rightly said, the art of being wise is the art of knowing what to overlook. The author has been wise and dealt with the core issues of patent law in his first book. Surely this is just the beginning, and the academic prowess of Ramanujan would continue to blossom in the interest of the Indian IP community and for the growth of patent law. Thanks so much for those effusive words, Honorable Justice Pratibha M. Singh. With that, it's a delight to be introducing Senior Advocate Abhishek M. Singhvi. It's a formal introduction. Trust me, for those who, the tax professionals, we cater to a huge tax community of 25,000 readers. For those who've not had a chance to visit the High Court too often, because usually chartered accountants stop at the Income Tax Appellate Tribunal, please do make it a point to hear Dr. Singhvi argue. If he argues more in Delhi, but the next time he's in Mumbai, do take out the pass at the Bombay High Court and hear him argue, or even at the NCLT. The courtrooms are packed when he argues. I saw that at the NCLT. It's a pleasure to introduce Dr. Singhvi, and I'll try to keep this a bit short because we want to hear him more. Dr. Abhishek Manu Singhvi is a senior 3-term sitting MP. He's a former chairman, Parliamentary Standing Committee on Law and Justice. He was India's youngest designated senior advocate at 34, and India's youngest additional Solicitor General at 37. He's a well-known author, columnist, and a visible media personality. He's also the senior most serving national spokesperson of the Congress Party and a former vice president of the Supreme Court Bar Association. He's a prolific author, prolific writer in so many publications, author of innumerable articles. Dr. Singhvi's definitive 1.5 lakh word legal analysis of the law of emergency powers in a comparative common law perspective was jointly released recently by the present Chief Justice of India and 3 other Supreme Court judges in January 2021, awarded the Global Leader for Tomorrow Award by World Economic Forum at Davos in 1999. Dr. Singhvi has been the opening lead speaker for the Treasury Congress benches in Parliament for almost every major debate from 2006 to 13. I can keep reading on and on, but when it comes to development of jurisprudence, be it on corporate law, commercial law, constitutional law, you can pick a few lawyers, literally at the back of your hand on these fingertips, who are masters across these 3 subjects, and 2 of them are right here today in front of us. That is Dr. Singhvi. You throw any law at him, and he's a master at it. He supports many charities with large and significant contributions, including a standalone Prayas Center for Destitute Children, the Singhvi Scholarship at Trinity College, Cambridge, an oxygen express van and medical equipment for COVID and general medical assistance, and large contributions to the Supreme Court Bar. This is apart from the sterling work done by him over 12 years in Rajasthan from his MP LAD funds, supporting 400 projects in the field of health and education. A book on his 390 MP LAD projects in Rajasthan was released by the Vice President of India, Mr. Venkaiah Naidu, in February 2021. Dr. Singhvi topped India at the school leaving Indian school certificate exam and did BA Economic Honors St. Stephen's College and MA and PhD from Trinity, Cambridge. On that note, I would request Dr. Singhvi to speak on patent law. I'll be honest, I've never heard Dr. Singhvi on patent law. At least I've heard him on 25 other laws, but not on this. So I am looking forward.
Thank you, Arun, for a very generous introduction. And I will start from where you left off. Justice Pratibha Singh, my good friend, Mr. Vaidyanathan, the main person today, the author, Adarsh, the editorial staff and the publishers of Taxsutra, Mr. Gauri, Mr. Arun Giri, and all the others, ladies and gentlemen. Your last comment is really the first comment, because I take off from what Justice Pratibha Singh said, that she was so happy to share the platform with those with whom she had interacted as a lawyer. I must confess that I don't reciprocate that sentiment. I'm not at all happy to share a patent discussion platform with Justice Pratibha Singh. I find it very intimidating. I find it extremely pressurizing, and I mean it genuinely. And I have been, in fact, thankful that she has not given the patent or the IPR roster in the High Court, because there'd be precious little to be done by anyone. She is a walking encyclopedia on the subject, and any of us who speak on it, I think, are really doing what is said, that fools fear to tread. Fools tread where angels fear to tread. And I don't want to be doing that. But since today we are talking of a book release on patent, I am forced to do it. And therefore, here goes. As far as the book is concerned, I don't think I can add anything to the 4 points I made in my afterword, which is published. First, that just like bittersweet will always be an oxymoron, patent law simplified, inverted commas simplified, will also remain an enigma or an apparent impossibility. And on that count, the author deserves great kudos for traveling in the direction of simplicity within this turgid and complex minefield. Second, the presentation and layout, divided into pithy and precise sections and subsections, automatically leads to commendable precision, focus, and brevity. Thirdly, the extracts from important judgments across the globe on the fundamental principles of patent law is a very carefully curated collection. Of course, I have said so in the afterword that the book still has some few miles left to travel to match my all-time favorite casebook. I don't know if Justice Pratibha Singh remembers that. Tony Weir's casebook on tort in Cambridge. But Adarsh is well on the same direction, on the same path, and I'm sure that he will be modeling various editions on this subject. Last, legislative history, the pompously described travaux preparatoires, has always received less than the deserved analysis in most Indian books, and even in case law. In the Monsanto case in the Supreme Court, where Adarsh was assisting me, I found it highly enlightening to trace the original and the varying intent of domestic legislative framers, and even more of international convention discussants and draft persons. And therefore, I am particularly happy that Adarsh has focused a lot, wherever possible, on the legislative history in this book. This is as far as the book is concerned and the author is concerned and his presentation. As I said, despite the intimidation, let me venture to add a few larger points with respect to policy and reform perspectives. First, though exact figures are not available, best estimates indicate that around 5,000 plus IPR cases are pending in the Delhi High Court. This, of course, includes all kinds of suits, appeals, writs, etc. Within this, there'd be about 1,500 original IPR suits, appeals, suits, and possibly 15% of these would be patent related. These are Delhi High Court figures on best estimate or guesstimates, but the figures would obviously be much, much higher if aggregated from trial court to Supreme Court across India. Our demands for specialist IPR tracks, and I know sterling work is being done in these rules which are published for discussion for the IPR division, but everyone, most of all Justice Pratibha Singh, knows the reality of the huge manpower deficiency which all high courts have to suffer with. So specialist tracks for arbitration have not been possible. Specialist tracks for IPR, I don't know when they will be possible with not enough judges to go around, but we all live on that hope. But something must be done along with that to ensure that the great robustness of the IPR system and the jurisprudence India has painstakingly developed, especially in our premier high courts, is not undermined and the gains we have made are not frittered away. In this connection, we have to note that ADR, and I use ADR in the wider sense, has expanded immeasurably as the second bypass after arbitration, which was, as you know, the first bypass having failed to declog litigation arteries. Is there a way we can create arbitration in ADR structures which allow such patent disputes to go down the ADR route to the maximum extent possible, where consent of disputants is clear? And now I find very interestingly in rules which have clearly the imprint of Justice Pratibha Singh, Rule 12, even where the disputant's consent is not available. Namely, there is a mandatory power to send it once for that. Now, in this regard, I think we need some more statutory clarity. Licensing and infringement disputes have been held in India to be arbitrable. In Enercon, the SC permitted arbitration, and this was broadly affirmed in the more recent Vidya Drolia case. But, and of course, following Vidya Drolia, we have High Court judgments, and some even before Vidya Drolia from Bombay and Madras. Delhi High Court judgments like Hero Electric and Golden Toby, and others in Bombay and Madras, which have held that in principle, these disputes can be arbitrable. Now comes the conundrum. The same judgments also accept, as they should, that the IPR validity ultimately operates in rem. And the operative word here is validity, the patent validity issue. And validity issues being in rem cannot be arbitrable. This again, Vidya Drolia, the same case says in para 76, as it should. Now, this creates a simple paradox and confusion because 90% cases, at least most of the cases I've appeared in, and all of you would know better, where there is a infringement action, the defense to infringement would be invalidity or issues of validity. I don't know of many cases at all where this would not be so. So what do we do then? Then, you say on the one hand that yes, it is arbitrable, but then validity being involved, it is in rem and not arbitrable. Incidentally, I find that Justice Ramanna, as he then was, in his supplementary opinion at in para 219 in Vidya Drolia, recommended that other countries, like other countries, even in rem disputes should be made arbitrable by an amendment to the statute. That is just by the way, because that has been the suggestion which I wanted to make. I checked up the US and UK position. Statute 35 in USA, added expressly for this purpose in 1982, expressly allows arbitration for both infringement and validity issues. Now, how does it get around this issue of in rem? Very simply, which is what I think India should clearly provide by statute and equally clearly by case law, but statute is better for clarity. They get around it by saying rightly, I think, that when the award is given on both infringement and validity issues, it would have only in personam binding effect on the parties. That's the simple statutory rule. We have the kind of skeleton of that rule here and there in the case law, but it's scattered and therefore diffused in India. This position appears to be similar in the United Kingdom, in Switzerland, in Italy, and this is the way to promote the larger ADR concept amidst patent law, while preserving the in rem nature of such disputes. And as I said, we do not in India need a case-by-case approach only that takes long, it creates some contradictions, there is less clarity and stability. Perhaps we need a statutory amendment. Incidentally, I found that globally, international arbitrations are having huge amounts decided and awarded in patent disputes. Of course, many of them may not involve validity issues, but patent licensing, agreements, violations, breaches, and overlapping issues of validity. You've had the Nokia case, which Nokia won $218 million in an ICC arbitration against Samsung for the misuse of Nokia's phone patents. Another ICC award gave Tessera $125 million for Amcor's breach, and Interdigital again got $134 million against Samsung. So it is growing, but there is, I think, a psychological barrier in India. both amongst judges generally and practitioners, and I certainly had that psychological barrier when I came into this field, that this is a no-go area. You say ADR and you say patent, and immediately says no-go area. There's some kind of a different path out there. That should not be so. That is not so, and we should work it out to the extent of not rendering all ADR futile for this area of law. Last but not the least, let me raise another policy issue, which I've felt as a practitioner for a while, and I bounced it off Adarsh, and I asked him whether I look like a bit of a fool saying it. So he said, no, I can assure you, you're okay. Go ahead. That is this. Should we not consider enacting, obviously this can be only by enactment, some sort of presumption, howsoever restricted, the wording is up to the legislature, it can be restricted, some sort of presumption in favor of registered patents. The way I see it is that patent registration as per the current law is no proof of patent validity. We all know that. If a defendant makes out a case that firstly, that his defense is not frivolous, or better put, has some credibility, this word credibility is interesting, injunction will be denied. Now, I don't know of any clever lawyering and a complex technical minefield which cannot make out a credible defense. Also, a credible opposition, even post-grant, will deny the injunction. And there are Delhi High Court division benches, I'm told, Roche and Cipla and Merck, some of which I had occasion to appear, suggest so. Well, I ask the question, is it not time as a policy perspective to underline and re-emphasize the obvious point that patents are granted after long and multi-layered scrutiny? You have the section 7 to 10 procedure, which requires very detailed applications. You have the 11A requiring prescribed publication. You have the 11B to 13 requiring detailed examination, including anticipation and prior claim issues. You have the 14 requiring consideration by the controller. And then, of course, you have 15 to 20 giving the controller a fairly comprehensive, vast set of powers for invasive scrutiny. And then, of course, you have the two most famous, 25.1 for pre-grant and 25.2 for post-grant. With so many bites at the apple, a poor chap who has crossed this obstacle race of multiple steeplechases lands up in a court in an injunction matter with absolute zero weight attached to the patent. I find that a great paradox. Perhaps I'm speaking too much like a layman, but I find that a paradox, a huge paradox. And therefore, I plead for some kind of, let me use the phrase very accurately as lawyers do, restricted presumptive statutory validity. To what extent you want to restrict it is a matter of detailing. But certainly some restricted presumptive statutory validity, time has come to consider it. Yes, I understand, although I don't practice at that place, that it is necessary to weed out the corrupt elements in patent registries. Let's be blunt and let's be frank. I understand that it is important to strengthen their infrastructure. And I also understand that there is a trust deficit out there. There are allegations that a large number of undeserving things get patented. But that is no reason to give some limited, restricted presumptive validity after a fairly arduous obstacle race, which the applicant has won. Mere credible defense, which can defeat an injunction, which is the present state of the law, I find is not perhaps the right balance. There are two sets of balances, counterbalances, in favor of what I am saying, which were sought to be created by judgments of the High Court. Not by statute, but by judgments. Merck, in the Glenmark-Merck case, the division bench of Delhi High Court righted the balance or tried to right the balance partly by emphasizing that whether the defendant exercised his right to challenge patent at pre-grant or post-grant, the so-called clearing the way argument, would be a factor to be considered and given some weight when the court exercises the discretion to grant or deny injunction. So there is some attempt, I think, there to right the balance. The 3M decision, similarly, by another bench of the division of the Delhi High Court, attempted another kind of balancing by holding that if the same facets of prior art and the same issues have already been overcome in the patent office, the burden imposed on the defendant should be treated as higher. Now, these are nuanced, calibrated judicial approaches, I think, emanating from the basic object of righting the balance. But they also underline the point I am precisely making, which is that clarity, consistency, and stability in such rules of the game can only come by some clear statutory amendment, giving some presumptive validity, howsoever minimal, to a registered patent. A case-by-case approach will breed uncertainty and inconsistency. The US model, an attempt, and I end on this, to balance these competing equities, therefore deserves a close look. There exists in that country, that is the US, a statutory presumption of validity. But equally, an interim injunction can be defeated if the defendant shows vulnerability or raises a substantial question of validity. Now, I understand that these are words, but they need not be mere semantics, and they can be fleshed out by certain definitions and by certain case law. This approach is found in several US judgments, which I have with me here, which I'll not bore you with. But I think this is the second issue apart from ADR, which I thought I will suggest as policy perspective or reform perspective. Well, let me again thank everyone. And let me in particular wish the book all success and the author Godspeed. And let me in particular look forward very keenly to another great publication which I just heard about, hopefully out in the next year, from Justice Pratibha Singh. I don't know how she will manage issues of estoppel as a judge after that. Thank you very much.
Thanks, Dr. Singh. We are just getting warmed up. We still have one talk, and again, from one of the doyens of the bar, Senior Advocate C.S. Vaidyanathan, and post which we'll have a Q&A. Dr. Singh has presented a new thought, and we'll ask everyone what they think about the thoughts that Dr. Singhvi has left us with. Senior Advocate C.S. Vaidyanathan, born on 8th August 1949. No, I'm not saying this to highlight that he's born 2 years after independence, but I just realized that Sir shares his birth date with one of my favorite sports players, Roger Federer. Or should I say the other way around? Yeah. His place of birth is Coimbatore, Tamil Nadu. My native place is 350 kilometers from there in Tanjavur. He did his Bachelor of Law from Madras Law College, an iconic law college. At the age of 21, enrolled as a lawyer, joined the chambers of Mr. K.K. Nambiar and Mr. K.K. Venugopal, senior advocates, Madras. He shifted practice to the Supreme Court in January 1979 and became an advocate on record in the Supreme Court, designated a senior advocate at the young age of 43 in 1992. Appointed as the first additional Solicitor General by the Government of India in April 1998. He continued in that position till October 1999. As a law officer of the Government of India in 98-99, appeared for the Government of India in a number of sensitive and important matters, including high-value taxation issues, both direct and indirect. As a senior counsel, has been involved extensively in a number of disputes in the infrastructure sector, including on the regulatory aspects, particularly in the field of telecommunication, broadcasting, power, mines, airports, etc. He appears extensively in patents, competition, IBC disputes, apart from matters involving constitutional law, administrative law, environment matters, has also been involved in a number of arbitration. Look at the wide gamut of subjects on which Sir can speak. And one of the great things is that you give him any tidbit. He has so much background knowledge already that he can argue for hours and hours and hours. Isn't that the traits of the legends in the bar, that they can stand up on their feet almost for a full day, and we the journalists, by the time it is 1 o'clock, 1:30 at lunchtime, we pray that Honorable Justice Pratibha, I'm saying all the judges at the Bombay High Court, please call for lunch. Please, we wait for the people to ring the bell. We lunchtime hona chahiye, so that we get a break from standing up on our feet for 4 hours. That's the travails of being a journalist. He's appeared in several interstate river water disputes, including Kaveri, Ravi Bias, Narmada, Vamsadhara, and Krishna. He's been a special public prosecutor on behalf of the Special Investigative Team before Gujarat High Court and Honorable Supreme Court. He's appeared in several election symbol disputes and disqualification cases, has appeared in several matters of public interest in pro bono capacity, including for Ram Lalla Virajman in Ram Janmabhoomi case, for the Podu Dikshitas in the Chidambaram temple case, for the petitioners in Ram Setu case, on the petition for making Sanskritam a subject in all CBSE schools, for the petitioners in the Gangotri temple matter, has been advocating the cause of higher levels of independence and freedom for temples and religious institutions in managing their affairs at various fora, including the High Court as well as the Honorable Supreme Court. I can go on and on, but just a few more things. He's founded a chair on law and developed in Sastra University, Tanjavur, has initiated annual lectures in the name of the legendary constitutional lawyer, Sri M.K. Nambiar, has founded, helped found, and support charitable institutions for uncared for senior citizens and children, has been supporting institutions of propagation of Sanskritam and Vedic education, has been actively supporting financially deprived Vedic Pandits, priests, folk artists, and musicians, has appeared in courts pro bono for teachers, ex-servicemen, charitable institutions, hospitals, and human rights organization. Vaidyanathan sir, I'm sure we'll hear from him an exposition today on patent law and some words from Vaidyanathan sir on the book that Adarsh has authored. A pleasure, sir, to be hosting you at this book launch function by Thomson Reuters and Taxsutra. Pleasure.
Thank you, Arun. I don't want to consume the time that you mentioned. I would be very, very brief. I'm very happy to be in the pleasant company of Justice Pratibha Singh and my good friend, Dr. Singhvi. I must compliment the publishers and the organizers of the meeting before I compliment my good friend, Adarsh Ramanujan. A huge round of applause is due to Adarsh. Compliments and congratulations to him at such a young age to produce a casebook of great significance on a very important subject of patent. It's a very creditable achievement, and generally the academics write books. For a busy practitioner, it is not easy to devote time, spend so much time to write books. It's either because they don't have the time or it's not rewarding enough. Either way, it's there have, of course, been some exceptions like Mullah Palkiwala, Data, Dr. Singhvi, and Adarsh now joins their ranks in coming out with a book, sparing time, and it's an exceptionally good book. And going forward, I'm sure you will produce more of such books. It must have really meant a huge sacrifice to devote time for this. And of course, because of his passion, he has been able to do that. And I'm once again congratulate him and good wishes. On the book, there are a number of interesting developments, as he mentioned, which has called for the revision now in the short period of 1 year. And Unveil and Regeneron and the attempt to reopen some of the cases in US also, which have been not allowed. Therefore, these have really warranted a revised edition. And it's good that you have been able to come up, Adarsh, with a revised edition. On the book, on the organization of the book and the way in which you have presented, a number of things have been said by Justice Pratibha Singh and Dr. Singhvi. I don't want to repeat it, but I just want to say a few things. Those who have gone through the book, the first edition and the revised edition, will notice that chapters 7 and 8 are the longest, and for a very, very important reason, because they deal with patentability and claim construction. And we have had a number of cases in India which raise this subject, and therefore, naturally, Adarsh has devoted considerable amount of pages on these aspects, because they do raise vexed questions. On the subject of patent law, one of the things that a common man asks, why should a drug which is needed essentially for a muscular degenerative disease for a single shot cost as much as 16 crores? It's a very important question. Of course, if you take away the taxes, a large part is because the pharmaceutical company which has come out with it has priced it so high. And the justification for that is that they have incurred huge expenditure for developing this product. I think there has to be a way out. In the plant protection law about which Justice Pratibha Singh mentioned, there is a provision for computing the cost and giving a reasonable profit. I think some such way will have to be found in respect of such essential drugs. Otherwise, the common man can simply not afford, and I don't think the governments are in a position to raise finances to fund all of them. It's simply not possible. So we have to find some other way. Yes, the bargain that a patent involves is that you have exclusivity for a limited period and you exploit it. And whatever expenses you have incurred, you recoup it and make some profits. But it can't be to an extent where the public are made to suffer. Therefore, I come from a school of thought where I believe that there has to be some kind of regulation in regard to this. I do not think laissez-faire economy can prevail in regard to patent and for the patent holder to price in whatever manner he likes. I think there has to be some kind of a restriction in regard to this. I believe that. Now, the other sensitive question that Dr. Singhvi raised, and I want to react to that, in regard to presumptive validity. I'll give you two instances. And I want to ask myself the question, how could there be possibly presumptive validity? You have a pharmaceutical element A, another pharmaceutical element B. Both no longer are patent. The patent has expired. A combined administration, one following the other, A followed by B, is now given a patent. I simply can't understand now how can there be any presumptive validity in regard to this. Somebody has gamed the system and got a patent. Either the patent office does not have the competence to assess it, or there has not been effective opposition. This raises a very serious question. And for 3 years, an ex parte injunction which has been granted continues by the patent holder gaming the system. It's simply unimaginable that the patent specification itself says you first give A in a separate dose, follow it with B, and that's a combined administration, and that has been given a patent. It's simply illogical. Now, the second I'll give you, and it's an argument by an eminent counsel which was advanced in support of a patent. I have found the Sanjeevani hill and I got a patent. I do not know where the Sanjeevani plant is. It's a huge hill I have found. I have got a patent for that. I will now, I have spent much more time, money, and effort to locate the Sanjeevani plant, and I will get a separate patent for that. So, to me, as a common man, it sounds so illogical. And to say that for that, there should be a presumptive validity doesn't appeal to my sense of just fair, reasonable approach in the matter of assessment. These are the kind of questions that one will really have to face. How could there be any monopoly conferred in regard to Sanjeevani Hill? Nobody can explore it. Nobody can look for the Sanjeevani plant, and as and when the Sanjeevani plant is found, and somebody uses it again, there will be a separate patent in regard to that. This simply doesn't appeal to me at all. Therefore, this kind of double patenting conundrums and the question of disclosure and question the coverage and disclosure questions that have been raised in Novartis, which I mean, some of the persons, eminent persons who are now on the speaking have partaken in. Now, these, therefore, in respect of genuine patents, there is very, very limited dispute, very, very limited litigation. Most of the litigation today is on account of patent holders seeking to game the system, is my view, from the light of experience that I've seen. Yes, in regard to standard essential patents, there are persons who have been abusing it by the person dependents, and there have been issues with that. And that's mainly because of some regimes like China and others who have been allowing this kind of exploitation of knowledge, even without paying any royalty for that. Now, one other question I want to raise. There is a chapter on remedies. The remedies for the patent holder. What happens to the remedy for the defendant who is prevented from exploiting whatever he has invested money in coming out with a product, and he is stopped by an injunction? Say 2 years, 3 years. Ultimately, the injunction is vacated. How is he to be compensated? How are the public to be compensated? What is the extent of application of mind so far in regard to this aspect in any patent law regime? I think this is something which needs to be considered, because the public who is deprived of pharmaceuticals, medicines at a rate at which he can afford is not compensated. He is asked to pay a much higher rate during the time the patent regime is enforced, and an injunction is granted and continues for years. Ultimately, if they don't succeed, the person who got the injunction should be directed to restitute the person who was prevented from launching his own product, and the public who was prevented from getting the product at a subsidized, at a rate which the rival would have been able to offer. I think this is an aspect which needs to be considered also. I thought that this also needs to be focused on. I think the author should consider studying how this is to be dealt with by the law. And Dr. Singhvi, as a parliamentarian, should take steps for the purpose of getting the law amended to ensure that a person who has got an injunction which ultimately he does not succeed in compensates the persons who have been deprived of the product. I think these some of the things Dr. Singhvi also mentioned about the alternative methods of dispute resolution. I think one of the things that has been successfully tried in some of the other jurisdictions is in matters like this, attempt mediation and offer terms of settlement. And if a person unreasonably does not accept it, and if he ultimately does not succeed, huge punitive cost should be imposed on the litigant who is so unreasonably withholding consent to any attempt at settlement. I think that has to be done as a measure, so that litigation should not be, the court system should not be gamed, the patent regime should not be used to the detriment of the public. I think these are some of the thoughts that I wanted to share. I don't want to take more time. We have already gone beyond the time that we originally estimated. Thank you everyone for giving me this opportunity. Thank the organizers. Thank Dr. Mr. Gauri Shankar Natesan, Mr. Arun Giri, every one of the organizers. Thank you very much.
That was thought-provoking. Who said patent laws are boring? Until I started covering cases in the High Court and Supreme Court, even I thought, who will cover legal cases? I thought that because no one else wanted to cover, being the junior most reporter at CNBC, I was always sent, like the graveyard shift, they say at jobs. This was like, go to the courts and cover, just sit and wait for the case to come. But legal reporting has evolved a lot over the last 15 years. That's because legislations have evolved, controversies have evolved. You have two different strands of thought, but both Mr. Vaidyanathan and Dr. Singhvi, both of them, I think, have minced no words in saying that this gaming the system has to stop. So, but of course, 20 years back when I was doing my CA foundation, at that time, we all thought that WTO had become the hotbed of all the intellectual property disputes, and how the Indian IP system was not robust enough. And so much of the pressure we used to face 18, 20 years back was about India not having a robust IP protection mechanism, with the sort of judiciary that we have. And I think Dr. Singh, also Justice Pratibha Singh, also mentioned that we need to have more judges who are from the IP field. Maybe I can put the first question, to Honorable Justice Pratibha Singh. You mentioned about more judges who have IP background. At the same time, if you look at some of the other tribunals, like the Income Tax Appellate Tribunal, specialist judges have been there. NCLT, again, some specialist judges, but especially the ITAT experience, where you're producing 150 income tax rulings a day, almost. And we have to go through each one of them and find the report-worthy ones and take it to our readers. You think that doing away with the tribunal was a good move, or the tribunals are better equipped to deal with these specialized subjects than possibly the High Court, where only important principles of law should be adjudicated? I just thought maybe you could take your take on
that. It's a very relevant question that you raised, Arun. The scrapping of the IPAB, I personally speaking haven't read any piece on what was the reason for scrapping it. I don't know. I don't know the reason, actually. So I'm not so sure. But IPAB had its own problems during the times when we had the IPAB manned by good chairpersons, whether it was Justice Sridevan or Justice Manmohan Singh. They were able to deliver a lot of work. But it was, I think, because of lack of financial autonomy and lack of proper appointments, timely appointments, non-constituting of benches, that the IPAB couldn't function fully to its absolute, to its absolute potential. That's the first thing I can say. Now that the event has taken place, I don't want to go into whether it was right or wrong, because it is spilt milk, as I would say. Now that it has happened, I think this should be seen as an opportunity by the judicial system for the IP cases to be handled. The multiplicity of cases can be avoided now, because there were multiple cases on the same patent. Challenges were pending in the IPAB and in the High Court. One would kind of wait for the other, or keep looking at each other. So in the IP division now, we've now introduced a provision for consolidation. So suppose there are 10 litigations for the same patent, the trial on the validity of that patent can be consolidated. So that would cut short time consumption on the validity and related trial. And it would be one trial where there could be 4 or 5 lawyers cross-examining one witness. So that should do the job. And I think that going forward, the IPD, if the mechanism is streamlined in the manner in which we are envisioning it, it should really streamline IP disputes in a considerable way. We have a 2-layered technical assistance which is contemplated under these rules. One is law researchers specially for the IPD. I think as a judge, moving from being a lawyer, duly assisted by several counsels, juniors and associates during my lifetime as a lawyer, to have law researchers has been a great boon for a judge. And to have 2 specialized law researchers who are having science-related background, who can answer basic questions within the chamber of a judge, whom the judge can trust, would be an amazing, I think, attempt to have some hand-holding for the judge on technical matters. The second level of technical advice which we're looking at is scientific advisors. We hope to draw up a list of scientific advisors, at least in the Delhi High Court, and maybe the list can be shared with other high courts, which don't only have experts from within India, but maybe even international experts, whom the court can say, okay, we have an issue on how royalty is to be determined in this matter. Let us look at an independent expert who has given evidence in various cases across the world, and he will be a court-appointed expert. If we can do that, or on an issue of pharmaceutical patent or biochemistry, if we can have an Indian expert or an international expert, then that would really help as well. I think these systems, if we put them in place and implement them well, I do think, coupled with 2 or 3 judges dedicated for IP matters, I think we can take this forward, because as Dr. Singhvi said, on the basis of guesstimates, which I don't want to confirm or deny in terms of the number of cases, the guesstimates would show that there are a number of cases, but I can say 80 to 90% of them are not complex cases, which are IP related. They're very, very small cases, trademark, appeals, writs, etc., which can all be handled. The biggest focus is on the patent matters. And if we can streamline them, the number is not very high. Streamline them right now, bring them on track, and then we are safe to go. That's what I would say.
On our corporate law portal, Law Street India, we covered 800 IP cases in the last 5 years, and that's not usually a strong suit. The heavy focus is on corporate law, company law, NCLT, but we have 800 IP cases from different high courts. Dr. Singhvi, I want to take this question a little further. On the one hand, and even wearing your hat as a lawmaker and as a senior advocate, a commercial lawyer, on the one hand, you had so many people always arguing tribunalization of justice, so many tribunals, everywhere tribunals. On the other hand, we've done away with Compact, merged it with NCLAT. We did away with now IPAB. We've done away with Advanced Ruling Authority, Settlement Commission, so many tribunals. The pendency is just increasing cases, especially after IBC has come. NCLT has almost become like IBC forum. We no longer see some cases of operation mismanagement and others, company law matters, but almost IBC every day. Dr. Singhvi, I think just if you look at how the tribunals have functioned in the last 5 years, they've really come under a lot of scrutiny. So where do you weigh in on doing away with some of them, merging some of them, and when we are talking of specialization in the field of law, so many subjects have become transfer pricing, income tax, they've become so specialized, patent law. Do we need tribunals, or do you agree that fewer tribunals? Dr. Singhvi, you're on mute.
Arun, the question you asked is a very large question and sufficient to have a whole day seminar on tribunalization of justice. I will give you very short, pointed answers. There is a larger issue and a smaller issue as far as the IPAB is concerned. The larger issue is tribunalization of justice started many decades ago. It has unfortunately largely failed, and obviously all generalizations are imperfect and untrue, and this also would be imperfect. But generally, I think it has failed because it has become a quantum numbers game. It was always intended to be a quantum numbers plus quality game. Now, unless we understand that by merely replicating and proliferating the numbers of the people is not going to help, that is what has happened across the country. Some of us have the privilege of appearing in all these tribunals, a very, very large number. And we have always jocularly suggested they should all be housed in 2 big buildings for the convenience of lawyers, not too far from the Supreme Court and the High Court. But in our appearances, what we find is that the manpower element, the human element, is the biggest casualty. I say it with great respect. There are shining exceptions, but the truth and the sad truth is that in the overwhelming bulk, and that is the reason for the failure. So you have simply transferred the clogged artery to a different artery. And on top of that, the satisfaction, which is there before a judge properly so-called at the High Court level, that satisfaction is missing. because for a variety of reasons, the pace, the independence, the understanding, the vigor, the analysis, all of them, unless the use. The whole answer to your question is, first and foremost, they cannot be sinecures. They cannot be postings for idle people. And I would blame everyone, mind you. I would blame right down from the Supreme Court downward, because ultimately 90% of them have Supreme Court persons and senior bureaucrats sitting on the selection panels. You cannot not be blunt and blame them, because they tend to defer and delegate that choice. And they defer to various views or various biodaters and various knowledges. In actual practice, what turns up in the bench may not be at all what they have envisaged. And that is the main problem, is point one. Point two, there are very, very good exceptions. I'll not take names. But the second problem has been long periods of vacancies on tribunals. Both, to take the IPR area, copyright boards and IPAB system, we have had a large number of writs already while they were thriving, these tribunals, where the court entertained and gave holding orders, what I call holding orders, that till the next time when the CP, the copyright board meets or the IPAB meets, you must get some interim injunction, because there can't be a vacuum for remedies. So that is been long periods of somnolence and vacancy, which should be avoided, which already denigrates and completely undermines the tribunal. Before you wind it up, you have already undermined it. And last, of course, is that there have been shining exceptions, which prove the point that if you make good appointments to tribunals, they've done very good job. I have personally appeared before the IPAB, and one of the names Justice Pratibha Singh took. A lot of hard work was done, a lot of disposal is done, but that's not the norm. That's a shining exception. Now, these are the three faults in a tribunal system, and this will continue. We'll keep on making some tribunal or the other without attending to the quality issue. There are lots of good people out there, anonymous, hardworking judges who don't get appointed, because appointments are a different story in themselves.
Thanks so much, Dr. Singhvi. Yeah, Vaidyanathan sir, I'll try to be a little provocative. Do you think MNCs, multi-billion-dollar giants today, you look at a Facebook, Google, I'm actually taking names, so some of you all may be associated with them as well. They're all billion-dollar market cap companies. Do you think this patent clause, some of them may be holding 20,000 patents, 50,000 patents, one has lost count, Apple, Google, Facebook, etc., Amazons of the world. Do you think that the regime is loaded in their favor? Now, forgive me if the question is too, if it's a stupid question, forgive me, sir. Is it loaded in their favor?
I don't see. There is a lot of innovation that is taking place. So you can't say that the patents are being granted for without any novelty or invention. There is a considerable amount of work going on, and that is an area which has been exploding in the last 2-3 decades. So, but yes, the problem is why the patent office should have very, very competent people, absolutely independent people, and they should not be simply bureaucratic approach. We need persons of eminence who are appointed to hold those posts, and not just equating them to undersecretaries and joint secretaries level, because these are subject matter experts who need to be put there, because the amounts involved in terms of generation of royalties or monies that can be brought in is huge. Therefore, you need people of such eminence to be appointed, and not treating them as simple ordinary bureaucrats. Therefore, I think we need to be conscious of that, and then only the system will be strengthened. And once the system is strengthened, then there will be genuine inventions which are granted the patents.
Thank you, sir. Just to interrupt your housekeeping call, I know Dr. Singhvi had indicated to me earlier that at 12:30 he has a hard stop.
So others, last word to you today. Others, last word. 30 seconds to you.
30 seconds. I will only close with an anecdote, since we are talking about policy level issue. An economist called something as a Cobra Effect. It was based on original anecdotal evidence during British India. Apparently, the British were worried about too many cobras after they had colonized India. So they announced an incentive package. that whoever is able to kill the cobras, we will give you a special incentive. So it happened very well for a while. After some time, people figured out, aha, so this is a game, good. Now let me breed cobras, put them in the market, kill them and take the incentive. Now, you can keep going around in circles to say, is the incentive wrong in the first place? Or is it the fault of the system that it is capable of being abused? Now, here is where what Dr. Singhvi and Mr. Vaidyanathan and Justice Singh, all three of them were chiming, the human element. Everything involves a human element. Sometimes that is the strongest link in your institution. And at the same time, it is also the weakest link in your institution. If the people involved in the institution, both sides, patent office, lawyers, judges, if everybody involved in the institution worked with that level of integrity, I don't think the level of abuses that we see today, or at least alleged abuses that we see today, are going to exist. Now, with that simple thought on the Cobra effect, I would like to thank all the dignitaries for having made the time and for being very candid with their comments and for contributing a lot to this discussion. I found it extremely enriching to have all three of you here and share your thoughts like this. It has been a pleasure. I am humbled and I'm extremely grateful to the publishers and the dignitaries. Thank you very much. And of course, I will now give it over to Arun Giri and Gauri to close.
Since everyone has a hard stop, we'll respect the time of the dignitaries and we close it here. Just a marketing line. In case you want to pick up the book, you can pick up the ebook on taxsutrareservoir.com. We have over 500 books on income tax, GST, corporate, commercial laws. You can get the book right here, other commentary right here on taxsutrareservoir.com. And of course, the hardback will be available in the market as well. So do pick up the book. And thanks once again to all eminent dignitaries and others making the time available for the function. Thank you so much, everyone.
Thank you.
Thank you.
Everybody. See you all. Bye-bye.
Thank you.
Thank you.
Thank you. Thank you.
Thank you.